Hello, everyone. My name is John Combs. I'm a securities entertainment attorney. Been working in the film industry for 30 plus years, 23 of those in Los Angeles, working with low budget independent filmmakers, helping them comply with federal and state securities laws when they're raising money from passive investors. So that's the key, as we've already talked about in an earlier video. When you're raising money from passive investors, you're selling a security. Therefore, you're obligated to comply with securities laws if you want to be legitimate and not have potential problems, enforcement problems. Now, this is my contact information, and feel free to get in touch with me to ask questions about any of this. I'm happy to hear from independent producers who are threatening to make a film. There's my website too, filmfinanceattorney.com. There, I've got my entire bio, so I won't go into that in this short video, but you can check that out if you like. Now, there are a number of decisions that need to be made whenever you're thinking about complying with securities laws. So let's go to the next slide and see what some of those decisions. Now, when you think about it, or you're contemplating or starting to raise money from investors, passive investors, through a securities offering, you have a number of decisions to make, a number of issues that come up right away. First of all, you have to decide whether you're doing a public offering or a private offering. Now, a public offering, same thing as a registered offering. And in fact, what you do is you register the offering, you prepare your disclosure document and send it into the SEC, and they have their attorneys and accountants review it and get back to you with comments and questions and so forth. And it goes back and forth till you're both approved. So it's very time-consuming, complicated, and expensive. Therefore, most low-budget independent feature film producers do not conduct public offerings. As far as I know, only 3 have attempted in the last 30 years, and all 3 have failed, even though some of them had recognizable names attached. So that ought to tell you something. So we're probably going to be looking at private offering or an exempt offering. Now, the first thing you need to know is get past this myth that's floating around in Hollywood, has been for years, that an exempt offering is exempt from all rules. Not true. I mean, I've heard people say that, oh, we were doing an exempt offering, we don't have to comply with any rules. Nonsense, okay? It's exempt from the registration requirement. That's what the exemption means, okay? You're exempt from the registration requirements. Now, I have to say that some of the requirements of a private offering or exempt offering are similar to a public offering, but just not quite as burdensome. So you have 3 choices. And these are SEC regulations. You can look them up on the internet and read them and enjoy them as much as you can. Reg D Rule 506B, Reg D Rule 506C, and regulation crowdfunding. Those are the 3 options, okay? So this is another decision that has to be made. So Reg D, and this is, I'm just giving you a quick overview. There's more detail here if you want to get into more detail. In fact, I wrote a book called Investor Financing of Independent Film, and that's got more detail about these very same topics. I'm just trying to give you an overview here. So 506B, you're allowed to raise up to 35 money from up to 35 non-accredited investors and unlimited accredited investors. So immediately we have to make a distinction between those two. You need to be kind of aware of what an accredited investor is. Basically, there are, I don't know, maybe 10 different definitions, 2 of which apply to individuals, and these are the 2 you're most likely going to rely on. An accredited investor is someone who meets the net worth test, and that means they have a net worth of $1 million or exclusive of their primary residence. So $1 million exclusive of their primary residence. The other is the annual income test, and that's $200,000. They earn an annual income of $200,000 or $300,000 with spouse. Okay, so those are accredited investors, and you can raise up to 35 money from 35 non-accredited investors, unlimited accredited investors in a 506B offering. There is one other burdensome requirement that a lot of people have problems with, and that is you have to have, you and others in your group have to have a pre-existing relationship. Not all of you, but at least one person in your group, in your producer group, has a pre-existing relationship that, in other words, knew this prospective investor before the start of the offering, okay? And that's a problem for a lot of filmmakers. So one of the things you have to do if you're considering a 506B offering is sit around with your group, your associates, and decide whether or not you know enough prospective investors to succeed in raising however much money you're trying to raise. And that's your decision. Another possibility is another SEC regulation that you may rely on for a private or exempt offering is Reg D Rule 506C. And this is for accredited investors only. No non-accredited investors can be in this 506C offering. And there's no limit on the number of accredited investors, and there's no pre-existing relationship requirement. So you say, well, that's great. But you must confirm the accredited investor status of each of these investors. And again, there's, several different ways to confirm the accredited investor status for these investors. The one I like is the third-party confirmation, where you create a form, and I've got a form that I can provide to my clients that tracks the SEC language that basically you give to each prospective investor and have them forward it to their attorney, accountant, investment advisor, banker, realtor, people who know their financial circumstances and can sign off saying, yes, this person is accredited. And that'll work. And you keep those in your file unless some question comes up later. Now, there's some other requirements here, like notice filing, which I'm going to do a little video on, and things like that. But that's the gist of those two rules, Reg D Rule 506B and 506C, and those are the two that my clients consider most of the time. But there is a third option called regulation crowdfunding, and that's different from donation crowdfunding because this is an investment, at-risk investment, and these investors are looking to make a profit, to share in the profits, a profit sharing agreement. It is designed for small investors, and there's a bunch of little complicated rules about how much money the investor can invest, what percentage of their income and so forth, which is kind of burdensome. And the one I think that hurts the most is that there's too many filings to make it worthwhile. With Reg D 506B and C, you're only doing, typically you're only doing one notice filing to the SEC and to each state that's involved within 15 days of the first sale, typically. And the other requirement is that you do a final notice filing after the offering is over. So that's not too burdensome. Regulation crowdfunding, you're talking about sending in copies of any advertising, doing a filing before the offering even starts, and doing filings during the offering and after the offering. So in my judgment, the SEC kind of shot themselves in the foot here by creating too much of a burden for this small investor type exemption. But it's available. Some people may want to use it. I don't know. There's some terminology that you need to be aware of to avoid being embarrassed in conversations with other filmmakers. So let's get to that. There are differing names for securities disclosure documents. So if I have people come to me from time to time, they say, well, I want you to help me prepare a prospectus. Okay, are you doing a public offering? No, I'm doing private placement or exempt offering. Well, the proper terminology is not prospectus. That's a specialized term, a term of art, as we call it, to describe the disclosure document used in conjunction with a public or registered offering. Okay, so if you're not doing a public registered offering, don't say your disclosure document. Don't call your disclosure document a prospectus. Okay. The terminology for any of the Regulation D offerings, whether it's 506B or 506C, is Private Placement Offering Memorandum, or PPM. So, and most of you have heard that term before, but that applies to Reg D 506B, Reg D 506C. Regulation crowdfunding, I kind of guess the SEC just sort of gave up on what to call securities disclosure document. So they just said, we'll just call it securities disclosure document. Okay. So just be aware that for public offering, it's a prospectus. For Regulation D offerings, 506B, 506C, it's private placement, PPM. Regulation crowdfunding is securities disclosure document. So now let's talk about some of the information that you would be expected to provide to prospective investors before they invest. And that's what we mean by disclosures. That's the information you put in writing, provide to each prospective investor before they invest, so they can make a reasonable decision about whether or not to invest. First of all, we're going to talk about the choice of entity. In other words, what is the investment vehicle? In the old days, we used to use the limited partnership, but today that's pretty much been replaced with the manager-managed LLC. Be aware that there are two different kinds of LLCs. There's a manager-managed LLC, which has passive investors, and the member-managed LLC, which has active investors. And so we're talking the investment vehicle for these offerings are typically now manager-managed LLCs. That's the investment vehicle. You're selling units in an LLC, manager-managed LLC. And so then we get to the name. What is the name of that investment vehicle? You can name whatever you choose as long as it's available through the Secretary of State in your state. Typically, I like to see something out of the title of the script, plus film production, which tells your investors immediately that it's a film offering, and the title of the script is such and such, and it's a film for producing a film, as opposed to distribution or development. In other words, you could have a development offering, you have a production offering, you can have a distribution offering. Same rules apply. It's passive investors to selling a security. So that's typically what I like to do with the name. So the investors know immediately, it's a film offering. This is the name of the film, and it's going to be for production as opposed to distribution and development. So then you get to the name, and now manager-managed LLC has to have a manager, somebody to run the show. That's really the producer group. The producers control this manager. And it can be an individual, although investors tend not to like to write checks to individuals. They'd rather write it to some company. And it can be a member-managed LLC with 2 or 3 people acting as active investors. But it doesn't have to be. It could be a DBA, doing business as, or a fictitious name company, as it's called in California. And it's not important that the DBA or fictitious name company doesn't offer limited liability protection, because once the manager-managed LLC is formed, it offers liability protection to both the members and the manager. So you could do a DBA or fictitious name company, which is less expensive than forming a member-managed LLC. Plus, if you have a member-managed LLC as the manager and a manager-managed LLC as the investment vehicle, investors sometimes get confused. You got 2 LLCs. So then the date and state of creation of that manager, we need that information in there, and the address and phone. The phone is the phone that you want your prospective investors to call if they have questions, that they need answered. And then a really important section, a disclosure, would be the narrative biographies of the key people attached to the project. And, 5 or 6 people at least. What you're trying to demonstrate here to your prospective investors is that you've gathered around you some experienced filmmakers who are capable of making a film, and give some confidence to these prospective investors. And don't be skimpy with your bios. Don't come in with just 4 or 5 lines or just one little paragraph. I mean, do 3 or 4 paragraphs and include names of companies, include dates, and if you say award-winning filmmaker, say what award and when. Don't include fluff or exaggeration or flowery language. And so, make some good narrative bios. And then we want to establish a minimum and maximum amount of the offering proceeds, including offering expenses. Now, there are filmmakers who want to come in and say, well, gee, I need money right away. I need to start spending money right away. Let's do a no minimum offering. Legal to do, but it's like shooting yourself in the foot, because investors know that there's an additional risk if you're spending their money right away before you reach an amount that allows you to produce a film. And so that's going to scare a lot of investors off. So I don't recommend that. I've had people try that. We got a client out there right now doing a no minimum offering, and for certain special reasons, he might succeed, but it's not easy. And so we normally do mini maxis. You could also do all or none, where you set a certain amount, say, okay, I'm going to raise $10 million, or we're going to give it all back to the investors and not produce film if we don't reach the maximum. So, or that stated amount. But we typically do minimum offering proceeds and maximum offering proceeds. So you set that amount. It needs to be a round number that's evenly divisible by the number of units that you're selling. And so let's say you're raising money and your minimum is 500,000, your maximum is 800,000. Okay, you want your unit size to be evenly divisible into both levels. So you're raising this number of units, you're selling this number of units, or up to this number of units. And the minimum needs to be enough to produce a film at the least amount, for the least amount of money. Because if you just raise enough money to produce half a film, then you've got nothing to sell, and the investors are not going to benefit. So most of the offerings that I work on are what we call mini-maxi offerings, a minimum offering proceeds and a maximum. Now, the other thing, most of the time, producers will send me a budget top sheet. And we're doing a minimum and a maximum, so we need two budget top sheets, one for the minimum, one for the maximum. And the second thing is they typically just focus on the budget, the production budget, and they don't provide anything for offering expenses like, hiring an attorney to do the securities offering, disclosure document, and so forth, or setting aside some money for LLC maintenance, hiring of an accountant to prepare the K-1s to give to the investors every year, or marketing to distributors, going to film festivals, things like that. Those are not production costs. It shouldn't be included in your budget top sheet. Include offering expenses, and then you have gross offering proceeds as the number you're working toward. That's the minimum and the maximum. Okay. Then the number of investment units and the price of each, that's kind of an arbitrary thing where you set your minimum and maximum, you set your unit price. For lower budget film, it could be 10,000, 25,000. For higher budget films, it could be 50,000, 100,000. I have a client now that's got a unit size of $1 million because he's trying to raise $15 million. And maybe he can do it. I don't know. It's going on right now. Just exciting watching this happen. But it's pretty arbitrary in terms of setting the price. The revenue sharing ratio between the producer group and the management group, or the producer/management group and the investor group, two different groups. Typically, we give what's called, we give 100% of the LLC's distributable cash, which is a stage in the film's revenue stream after net profits, because the distributor may or may not share all of the net profits with the producer. But whatever the producer receives, the net profits minus a few deductions to cover, as I said, LLC maintenance, hiring an accountant to prepare the K-1s, and then you get to distributable cash, LLC's distributable cash. And so we give 100% of the LLC distributable cash to the investor group. They share pro rata on a pro rata basis based on the number of units they have. And then until they reach recoupment, and you specially define recoupment in your disclosure document to be 120%. That is 100% plus 20%. Some people call that a bonus, but 120%, 125%. I've had one client go 112%. That's up to you. It's what you can sell. If you can't sell it, then you may want to come back and say, well, let's modify this a little bit, make it a little more investor friendly, by raising the bonus, so-called. And then once they reach recoupment, then you switch to 50-50 for the life of the entity, which might be 10 or 15 years. And that is 50% to the producer group, represented by the manager, and 50% to the investor group, again, shared pro rata amongst them based on the number of units each has. So here are some specific film-related contents or disclosures that you typically see in a film offering. And, of course, you have the title of the screenplay or film, and the date and number of script registration with the U.S. Copyright Office. And I don't recommend that you bother registering or waste your money registering with the Writers Guild. They don't really give you the rights that you need to protect yourself. So register with the Copyright Office. Let's be businesslike here and demonstrate that to the investors. And then the screenwriter name and bio. Again, no skimpy bios. Let's get a good solid bio in there. And a descriptive phase regarding the film's genre and log line, so we kind of know exactly what we're dealing with. The anticipated MPA rating, we want to include that. And then a screenplay synopsis. And again, don't be skimpy on the synopsis. I mean, it's not a full treatment, but something less than a treatment, but more than a log line. So, give us a good, tell the story so they know what they're investing in. And that's one of the things that attracts investors, certain stories. Target audience analysis. I mean, give some thought to who you think your people are going to be interested in your film, and lay that out. Plan shooting locations. You don't have to lock yourself in and say, okay, we're definitely going to shoot here, unless you are. You give yourself some wiggle room and say, well, we might shoot somewhere else, but this is where we anticipate we're going to shoot this film. And then the budget top sheet, we call the budget that goes into a PPM, the budget information, we call that in securities terms estimated use of proceeds. In other words, you're telling the investors where you anticipate spending their money, so they have a right to know that. You're not locked in on each line item and you have to spend that amount of money. You can move the money around once you get started, as long as you stay within the minimum, the maximum of the offering proceeds. And again, I think we talked about the fact that the gross offering proceeds is a different number than the production cost. Okay, you've got some other items in there like marketing to distributors and so forth, and so be sure to include that. The box office comparables is something else we normally put in a PPM for an independent film. 10 or 15 films that you think are similar in terms of the budgets or genre. Sometimes it's hard to get 10 or 15 box office comparables for an ultra low budget film or a very unique film, but just do the best you can. And then I have a section that go into more detail on box office comparables in the video about financial projections, which I think is already available. And so that's, specific film-related contents. Okay, here's what we've covered in this brief presentation. We started out talking about the choice between public and private offerings. Typically, you're going to do private offering and exempt offering. And we talked about the choice among private exemptions, either Reg D, Rule 506B or 506C, or regulation crowdfunding. And then we wanted to clarify that there are different names for securities disclosure documents for different offerings. And then we went over some of the disclosures for film offerings and some that were specifically related to film disclosures. And so that's just kind of a quick overview of securities compliance. For more detail, again, you can check my book, Investor Financing of Independent Film, and there are probably other sources that are available too. Now, here are other topics that I'm trying to cover in this series relating to investor financing of independent film. You got what's a security, disclosure controversy, failure to comply, SEC notice filings, financial projections, and finder fees. And I've got another that's not even listed here I think it's called the use and abuse of business plans. And so I'll try to get to that as soon as I can. So I hope you enjoyed it and found something useful. And best of luck to you.